Good afternoon, and welcome to our first Friday Digital Transformation Thursday. Inconsistent. We've had to move this session because of the recent typhoon. And we're very happy that we can continue this conversation. This is supposed to be our third in our digital human rights series, and now we'll be talking about an important concern, which is internet connectivity. And we're very excited with the topic today. But I guess first and foremost, I'd like to introduce myself. I'm JJ Vicini. I'm the managing partner of Vicini Law Office. As you may know, Digital Transformation Thursdays was intended to celebrate our 20th year of the firm. And we're discussing various issues relating to digital transformation. And today's show is no different. I'd like to remind everyone that if you want to have a certificate for attending today, make sure that you registered for this session at our webpage, www.dtt.ph, and then you sign up through Zoom, and then we will send you a unique link, and then you can make we're asking for a small donation. It's up to you how much you want to donate, and we'll send you an e-certificate for your attendance today. As you know, we donate all our proceeds to the COVID frontliners. And we've donated a substantial amount to two institutions already, UPPGH and Silungang Molave. We'd like to thank also our speakers who are helping us out and are also contributing to this cause. Okay, so today's topic is of interest to everyone, I'm sure, of high interest to everyone. I was thinking it's gotten to a point where I think it would not be funny anymore for people to say that internet connectivity or access to the internet is a human right, given that a lot of economic activity now, especially now, including access to education, depends upon access to good internet. And it's been a problem in the country. We've not, as a country compared to our neighbors, we've not ranked very high in terms of average internet speed as well as cost. One reason could be is that we are an archipelago, and that it might be more difficult to deploy internet connectivity in many places. And I'm sure there are many challenges, and some of those challenges are regulatory. And sometimes, and when it comes to the telecoms business and in the data business as well, changes in the law should have, or at least are expected to have significant impact insofar as the user experience is concerned. And today we're going to discuss a bill that is being considered by Congress precisely to address that concern, and it's called the Open Access in Data Transmission Act. And we have lined up speakers for you to discuss this in greater detail. Our first speaker is Grace Miranda Santos. She is the convener of the Better Broadband Alliance. She earned her Bachelor of Arts in Political Science from UP and a Master's degree in Public Administration, also from the University of the Philippines. She's a National ICT Research Consultant and Digital Technology Research Consultant for the Asian Development Bank. She's also a blogger for PH Telecom and ICT Issues in Telecom Asia, and a research consultant at the Philippine Science and Technology Development Foundation. She's a research fellow and external consultant at Learn Asia, and is a consultant for the Philippine Digital Infrastructure Study of the World Bank, and is the policy analyst and lead researcher for broadband connectivity for the Asia Foundation. We'd like to welcome Grace Miranda Santos.
Thank you, JJ. Good afternoon, everyone. Good afternoon, Attorney Roy and Attorney Oli. Thank you so much for inviting me to present today. As many of you would know, universal ICT access is my passion and my personal advocacy. When I first started as an independent researcher back in 2005, it has always been the key driver of not only what I do for a living, but also what I do as a person. So with that, I would like to share my screen. Okay.
Right, looks good.
Okay. So the topic for today is, of course, how to achieve expanded internet access and how to improve the quality of service, and ideally also how to achieve affordable broadband internet. So internet, of course, during the pandemic, we found to be the essential tool that allowed everyone not only to respond to COVID-19 challenges, but also the one thing that still helped us in continuing our daily activities, whether it's working from home or learning from home, or conducting business, commerce, and also e-health as well. It is the foundation for digital infrastructure and economy, as well as what will drive us towards digital transformation. Because without connectivity, then all of our internet services and apps, I'm sorry, online services and apps will have no value. Um, there are a lot of challenges 25 years after the internet first came into the Philippines. We have seen um, very good improvements, but then since we are a growing population and we are an archipelago, there remain a lot of issues that need to be addressed, specifically access to internet services. About 40%, if not more, of Filipinos are still not connected to the internet. 52% of all public schools nationwide do not have access to internet facilities, according to the Department of Education. And 57% of the 23 million Filipino households also do not use the internet. Now, we do hear a lot of different data coming from different sources. But it is important, I think, to look at the methodology by which the data were arrived at. So we are basing our analysis on the different sources of data and looking at whether or not these data can be considered as credible and whether they reflect the experience of people on the ground. Next, the main contention that I'd like to put forward is that new entrants and competition in the broadband sector are hindered by outdated policies and regulations. This was mentioned by Attorney JJ earlier, but I will expound on this later on. So with that as the problem, the key solution would be to put in place policy reforms. We need to create an environment where we are not focused on a particular segment of industry players. We need policy that will embrace different types of technology and ensure that innovation in terms of technological advancements, as well as new business models that are emerging, will be welcomed into the country in order to help expand digital infrastructure and help as many Filipino people as possible to access the internet. Uh, this, of course, has been discussed to no end, but it would help to remind ourselves how the internet is really valuable to our everyday lives. When you increase broadband penetration by 10%, studies as early as 2009 have shown that it would lead to improvement or an increase in the GDP of a country, of a developing country in particular. A country that was specific to the Philippines, done in 2012, found that mobile broadband adoption increased the Philippines' GDP by 0.61%. Now, this study focused on the early 2000s. So I can imagine that after the emergence of cheaper smartphones in the Philippines, I can imagine that this rate of acceleration would be much higher today. At the household level, it was also found by a study by Ericsson in 2013 that if you introduce entry-level broadband at half of an Mbps, it is enough to increase annual household income by $800. One other thing that became very apparent during the pandemic is that we need government to be online. The president, as early as his first SONA in 2016, already made mention of this, that he doesn't want to see people lining up under the heat of the sun or under the rain. He mentioned that he wanted the government to use the computer, but um, we think that it's safe to assume that he meant that he wanted the government to be online. So we don't want e-government just because we want everything computerized. We actually can base that decision on studies that have shown how much cost savings we can have if we shift from face-to-face or in-person government transactions going to digital. And as you can see here in the sample countries, there is a huge amount of savings that can be earned by the government for each transaction. Unfortunately, and this was my second point in my summary slide, there's still a lot of work to be done. This is an example of what the digital divide looks like in terms of infrastructure. Um, we note here that the NTC in 2017, and the data that you're seeing here is from 2017, a bit outdated, but this is just to show the disparity in terms of access to infrastructure throughout the country as you go to the different regions. So the maroon and orange colors are areas where either we don't have an internet service provider or there are internet service providers, but they are not enough to address the demand for internet services. And the percentages you see here come from the latest SWS survey, which asked about adult Filipinos whether they use the internet. And this SWS apparently has been doing this study since 2006. So it's actually very good to look at it because you see a time series of how access to the internet has improved over the years. But consistently throughout the year 2000, after the year 2010 leading up to now, we see that the percentage has not really gone above 50%. So total internet usage of adult Filipinos is about 45%. And NCR would register the highest number, but as you go outside of the metropolitan Manila area, you see that it's less than 50% for Luzon, and for Visayas and Mindanao, it's less than 40%. What you're seeing now is part of the results of the recently concluded National ICT Household Survey that was commissioned by the DICT. It basically shows you that at the barangay level, there is still inadequate digital infrastructure. So those without access to free Wi-Fi is about 88%. Barangays without access to fiber is about 70%, and those without access to cellular towers is around 64%. And as we go to the different regions, especially those that have lower income, such as BARM, the Bicol region, Cagayan Valley, Mimaropa, and Central Visayas, we see that the percentage of barangays that don't have access to these infrastructure is much, much higher. If you could zero in on the access of BARM to fiber optic cable, 99% of the barangays that were interviewed said that they did not have access to fiber optic cable. The main culprit and we've seen this in a lot of studies done locally and also by foreign observers, as well as multilateral development institutions, is that we are using analog era fixed landline telephone based policy in the age of the internet and smartphones. The picture that you see here is actually very accurate because the laws that we are using right now date back to the 1930s. We are using the radio control law to govern how radio spectrum or the invisible cable that connects all wireless devices is governed. So this is actually a rotary dial telephone from the 1930s, and it's actually quite heavy, and you can literally kill someone using this phone, although I don't recommend it. But we are using that law to tell us essentially how to manage spectrum, even if that law was designed for an era where radio broadcast was the main mode of not communication, but transmitting information one way. The next would be the 1936 Public Service Law or Public Service Act that gave the mandate to what was then known as the Public Service Commission, basically as the regulator of all industries where the private sector participants are allowed to take the place of the government in terms of offering services. The next would be the 1979 Charter of the National Telecommunications Commission, the industry regulator, which if you look at the EO 546 was actually just inserted there as a part of the Ministry of Transportation and Communication. Of course, in 1979, I was, I guess, a toddler at the time. The telephone was also the main mode of communication. The youngest of all these laws would be the 1995 Public Telecommunications Policy Act, which of course is the law for telecommunication services. And in that law, of course, the landline was still the key technology. In fact, many of the networks there, including the international carrier network and the mobile service network, would require that the operator deploy between 300,000 and 400,000 landlines. So I don't have to explain that the technology we use to communicate, to connect, and to essentially access information from around the world would be the computer, digital devices such as the smartphone. So how do we improve the situation that we are in now? Essentially, we need to have policies that reflect the needs and requirements of the digital connectivity age. We would need more and different types of players to essentially develop more infrastructure using different types of technology. And we need our policy to reflect how we now connect to digital devices. The Open Access in Data Transmission Bill, which I will explain in the next few slides, is actually based on a framework that first ensures that new entrants are able to get into the market that exhibits high structural barriers to entry. In some cases, there are actually, a more extreme framework that's being used where there is functional or structural separation of the different players that are operating in a particular network. I will explain that later, but essentially, open access can be different types of models. But the open access bill that's in Congress is just one type. So in an open access approach, you create competition in the different layers of the internet infrastructure or network So you're able to allow a wide variety of physical networks and applications to interact with each other. There are cases where in open access, you separate the physical infrastructure from the services, or those that offer the physical infrastructure from services, and the wholesalers from the retailers. But essentially, the goal really here is anyone can connect to anyone in a technology neutral environment, and you encourage innovative and low cost delivery of internet services. This is an example of the different options that the market players can adopt in an open access business model. So from the left, the fully integrated model, you have a single vertically integrated operator, meaning from wholesale to retailer, from international connectivity down to the last mile, even down to the devices that we're using. There is a single vertically integrated operator that installs, constructs, maintains, operates and maintains the infrastructure or the network. Um, in a way, the Philippines was at some point using this model. But more and more, we are seeing that, of course, you cannot really stop the developments in technology, and new business models will always emerge. So since we don't live in a bubble, we see that these different improvements and changes are coming into the country, although some of them experience difficulty because of the outdated policy and regulation that we have. So as you go from model number 1 to model number 5, you see that there can be a situation where your network operator and active network providers can be different from your retailers and the different iterations of the model. But essentially, there is the extreme model at the right side would be a fully separated um, network where the physical networks the providers of the physical networks are different from the retailers, and you usually can see this in countries like the UK, Australia is also doing this, New Zealand, and in I think maybe model number 4 or 5 would be also Singapore. So what is the open access in data transmission bill all about? There are 3 key reforms. We can summarize actually the different provisions of the bill using these bullet points. One is the bill wants to promote an environment where you lower barriers to market entry for internet service providers. It carves out internet service, which is a different service from telecommunications, out of the telecom service category, and ensure that for those that want to provide the network and services for internet service, you are allowing a simpler, more efficient way of allowing or licensing these market players. The bill also promotes the fast tracking and lowering the cost of broadband network rollout. And this is done through several provisions, one being the promotion of infrastructure sharing and the streamlining of the different permits and requirements as well. And also, co-deployment, co-location, and cross-sector infrastructure sharing, meaning you use existing and future infrastructure that can be found in other sectors, and essentially broadband networks can be deployed together with those other infrastructure. And finally, the bill also has provisions that would make more spectrum available for internet connectivity by providing transparency and also encouraging a more consultative process in spectrum assignment. So essentially, these are the challenges that the bill intend to address. So high barriers to entry, introduce a simple and efficient registration process, and remove the congressional franchise and CPCN requirement for those providers that intend to offer internet services only. So here you allow more and different types of players to build and operate the network. Just as an example of how outdated our law is, we are probably unique as we are the only country in the world, as far as I know, and I would welcome any, correct me if I'm wrong, but we are the only country in the world that still requires a franchise from Congress to be passed as the first step in licensing, and a certificate of public convenience and necessity, which is awarded through a quasi-judicial process by the regulator as the second step of permitting or licensing. And before you even get to the licensing part of, offering internet services, all other countries in the world, usually the licensing for internet network operators and internet service providers would be awarded either by the Ministry of ICT or by the industry regulator. And if you look at the more developed countries, such as South Korea and Japan, the requirement is just registration or notification to the Ministry of ICT or the regulator. Uh, the problem with having all of these different steps is that it takes a lot of time and costs a lot of money. And so we are essentially, we essentially have a licensing process that is designed for the big players only. We need to change our mindset because internet is not the telephone. Internet connectivity thrives when there is decentralization. It's essentially a distributed system where different nodes are interconnected. In fact, there's actually no room for a monopoly in internet because you essentially need to have different interconnected networks so that the whole infrastructure, the whole ecosystem is resilient. The more redundancy, the better, because then you'll have a robust system. So you don't need to worry that when there is a cable cut or a fiber cut, that all the systems will be down, because the internet will always find a way to get the data and route it somewhere until it reaches its destination. That is how different the internet is to a telephone or telecom network. So we need to ensure that our policy and regulation welcome small players, nimble, flexible players that are capable of installing, constructing, and also offering internet services at the local level, at the provincial level, municipal level, even barangays and communities. So if you have this kind of framework where you need to spend between a year and 5 years to get your license, of course, time costs a lot of money, and you can essentially imagine how restrictive this kind of licensing process is. Also, we need to change our policy and update it because the laws that we're using now are technology specific. It's designed for a particular technology, particularly the analog landline technology. And also, I would contend that you cannot lump all types of networks under telecommunications because there are other networks that can offer internet services. Just as an example, cable systems are able to offer internet. the the power transmission grids and even distribution systems in and there are cases in other countries that do this, are able to offer internet. TV white space can also be a vehicle for transmitting your data. So many other technologies and types of networks out there can offer internet services. Second, we need to address the problem of costly and tedious network rollout. Of course, the our friends from the telecom industry have always complained about this. So but it is not only the telcos that are experiencing this. Many different types of service providers at the local level, even the government itself, say that they experience this. But I am glad to hear that the government, through a joint memorandum circular between the DICT, ARTA, and other government agencies, are already addressing this. And recently, Congress also passed a law that will allow the president to, I guess, basically override all the different permits and regulatory requirements when there's a national emergency. So there are already steps being taken to ensure that this is addressed. Oh, and also, before I forget, of course, the DICT has also issued the Common Tower Policy, which I hope will address the challenges of the mobile network operators in deploying towers throughout the country. And finally, we need to make more spectrum available. Uh, we do know that there is a third telco that was selected, and the third telco was awarded a list of 4G and 5G, potential 5G frequencies. But we also should not ignore that many of the places around the country, especially outside of the urban areas, would benefit greatly from wireless technologies. And we need to make sure that those who are offering services in the periphery, the small players or um, you know, internet service providers who are actually already on the ground and serving the communities that are often ignored by the big players, we need to make sure that they are also given uh, an opportunity to use this valuable resource in order to connect communities to the internet. So there are other key provisions in the bill. One is that it mandates interconnection. Of course, interconnection is was a big issue in the telecommunications industry, but it's still an issue in terms of internet connectivity. We need to put in place service performance standards, or at least clarify the mandate of our government agencies as to who is in charge of setting, monitoring, and enforcing service performance standards. And penalties for violators are also proposed in the bill, as well as the right of internet end users. The bill is already filed in both houses of Congress. At the House of Representatives, Congressman Victor Yap, the ICT committee chair, has filed House Bill 57. There are other legislators at the House who have filed a similar bill, but the ICT committee approved a version that is very close to House Bill 57 that was filed by Kong Yap. The ICT committee approved this in November 2019, exactly a year ago, but it's still awaiting a committee report. In the Senate, the bill, Senate Bill 45, was filed by Senator Ralph Recto and is now co-authored by Senator Grace Poe. The bill was referred to the Science and Technology Committee, chaired by Senator Nancy Binay, but there is no movement yet. We are awaiting the Senate to conduct its first hearing on the bill. But the good news is that there is a growing number of organizations that are supporting the bill, or at least have expressed their support publicly for the open access bill ever since the pandemic hit. So as of November 2020, the the Cabinet's Economic Development Cluster, led by the NEDA, the DOF, and the DBM, have expressed their support for the bill. And they believe that it is part and parcel of how we can move forward beyond the pandemic and towards digital transformation. Recently, the Bangko Sentral ng Pilipinas also announced in a press statement that they are supporting open access among other legislative initiatives that will help ensure that that BSP can achieve digital no financial inclusion through digital connectivity. Both the Department of ICT and the National Telecommunications Commission have also expressed their support for the bill in various public hearings and meetings. And all of the other business organizations, think tanks, industry associations, and advocacy groups have also expressed support. Some of them have even written to Congress and to the President to make the Open Access Bill a priority legislative initiative. So with that, I end my presentation. I am, of course, here as lead convener of the Better Broadband Alliance. We are a coalition of different stakeholders pushing for policy reform so that we can achieve better broadband for the country. Thank you so much, and I'd be happy to discuss with our panelists and the attendees as well. Thank you.
Thank you, Grace. You can stop sharing. Okay, there. Okay, good. Our next speaker is Attorney Roy Ibay. He is the Vice President for Regulatory Affairs at Smart Communications. He graduated with a Bachelor of Science in Economics from UP. I believe he's my batchmate, UP. We're certainly together in the UP ECOSOC, Economic Society. But he acquired his Juris Doctor degree from the Ateneo Law School. He's currently the Vice President and Director of the Philippine Chamber of Telecom Operators, a Director of the Telecoms Infrastructure Corporation of the Philippines, a Director of the Telecommunications Connectivity Inc., formerly a Director of Telco. He's for more than 10 years now, the Philippine Delegation Advisor and member to the Philippine Delegation to the International Telecommunication Union, ITU. And he's a founding member of the Information System Security Society of the Philippines, or the ISSSP. He's also the head of Legal and Regulatory Division of Sun Cellular. Please welcome Attorney Roy Ibay.
Hi, good afternoon. Allow me first to thank the organizers of this forum for inviting me today as a resource speaker. Salamat, Attorney JJ Dicini. Hindi, one batch ahead ka sa akin sa Econ. Okay. Oh, pero pareho tayong tambolero, kaya doon tayo nagkakasama. Oh, ang ganda nung set mo sa likod mo. Very nice. And to my fellow resource speakers, Ms. Grace and Oliver, a pleasant good afternoon. So, the story of Philippine telecommunications has always been inseparably linked with the right to access and the means to provide connectivity. From the Ship Radio Law, which is the Act 3396, which was enacted in 1927, which made it compulsory for all ships to have a radio device, to RA 7925 in 1995, which had as a major objective to promote and govern the development of telecommunications and the delivery of public telecommunication services in the country, to the more recent Free Public Wi-Fi Law, or RA 10929 in 2017. The government had come out with law and policies to promote access and stimulate the growth of telecommunications connectivity. And the results were seen not instantly, but a lot often many years after. And even up to the present, debates are still prevalent in the attempt to analyze how regulatory policies intertwined with the economic, political, and corporate or business occurrences in the past 25 years, which had led to the state of telecommunications at present. And now we have the proposed Open Access Act, which currently sits as a bill in both the Congress and the Senate. So I will not tackle the fine details anymore of the proposed Open Access Act. because this was also discussed already by the previous panelists, but only limit my discussion to the following. First, which version, the Senate or the House, would present itself better and why? Second, what are the possible legal challenges? And third, what are the possible ramifications or consequences if it is passed? And fourth, some recommendations or inputs to better the bill. So, on the first point, between the House version and the Senate version, personally, I prefer the Senate version. Although there is still a common provision in both the Senate and House version that will possibly open it to a legal challenge, but this I will tackle in point two of my discussion. But suffice to say, for me, the Senate version is a better one. Why? Because it mentions in its section 5, paragraph B, that a data transmission industry participant shall not be required to secure a congressional franchise and or a certificate of public convenience and necessity in order to construct, install, operate, lease, or own networks and facilities, except if A, it owns and operates an international cable landing station, or B, it provides a nationwide backbone network offering services as a carrier's carrier. And for purposes of this law, the term nationwide means that the backbone network provides a coverage of 80% of the municipalities and 100% of the chartered cities. So this only gives substance to Section 10 of RA 7925, which states that only entities which demonstrably show technical and financial capability to install and operate an international gateway facility shall be allowed to operate as an international carrier. The entity so allowed shall be required to produce a firm correspondent or interconnection relationships with major overseas telecommunications authorities or carrier. And under RA 7925, let us not forget that IGF operators were made to roll out 300,000 lines way back in 1995 just to be given the privilege to operate an international gateway facility. Okay, so we move on to number two, or the possible legal challenges. The provisions common to both versions that will be open to legal challenges are the following. Number one, the carving out of the definition of data transmission from the general definition of telecommunications as contained in RA 7925. And telecommunications is defined therein as any process which enables a telecommunications entity to relay and receive voice, data, electronic messages, written or printed matter, fixed or moving pictures, words, music or visible or audible signals, or any controlled signals of any design, and for any purpose by wire, radio, or other electromagnetic, spectral, optical, or technological means. And number two, the bill stating that qualified participants need not be Filipino companies or at least even 60% Filipino-owned. These two provisions of the Open Access Bill drive right into the raging question popular nowadays. Can Congress directly amend provisions of the Constitution by legislating new definition of terms such that certain limitations found in the Constitution can be skirted? As we all know, there are three ways to amend the Constitution. These are specifically provided by the Constitution itself. Number one, convening Congress into a constituent assembly. Number two, holding a constitutional convention. And number three, holding a people's initiative. In all three methods, the proposed amendment becomes effective only if it is ratified by the people in a plebiscite. Interestingly, Congress has found a fourth way not specified in the Constitution to amend the Constitution. The House intends to redefine constitutional terms through an ordinary law in the process do away with notification by the people in amending the Constitution. In the many deliberations by the Constitutional Commission during the drafting of the 1987 Constitution, telecommunications are very much mentioned to be a public utility, which meant being a Filipino 60-40 and needing a franchise. The deliberation of the 1986 Constitution Commission were very clear in stating that telecommunications companies are public utilities. And no less than the chairwoman of the Constitution, Commissioner Munoz Palma herself stated during the deliberations, and I quote, "In other words, there was understanding among the commissioners that commercial telecommunications was included in the term public utilities. So there is no question, therefore, Commissioner Suarez, that commercial telecommunications was considered as part of public utilities when the Commission decided on the equity ratio of the 60-40. But by carving out the definition of data transmission from telecommunications, all the requirements are pertinent to a telecommunications company applying for a franchise and being a Filipino corporation, or at least 60/40, will now outrightly be dispensed with as I read it. Okay. So let us assume for discussion's sake that it is perfectly okay to define data transmission as a subset of the general definition of telecommunications. Let us now even go further and assume that it is also okay to open up the four segments as in the House version, meaning international gateway, the core, the middle mile, and the last mile to companies that are not Filipino, or to those at least 60/40 Filipino but without the requirement of a franchise. But the provision I am most certain that can be challenged on constitutional grounds that is contained in both versions, the Senate and House, of the Open Access Bill would be the provision which includes the use, allocation, and assignment of finite radio spectrum resources to be used by the transmission industry participants without qualification. And I repeat, without qualification. Common to the Senate and House version of the Open Access Bill is the provisioning of spectrum for the use and of all or any data transmission participant. But what does the law provide? RA 7925, Article 2, Section 4 states that, Paragraph C, the radio frequency spectrum is a scarce public resource that shall be administered in the public interest and in accordance with international agreements and conventions to which the Philippines is a party and granted to the best qualified. The government shall allocate the spectrum to service providers who will use it efficiently and effectively to meet public demand for telecommunication service and may avail of new and cost-effective technologies in the use of methods for its utilization. While the 1987 Philippine Constitution states in Article 12, Section 2, all lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all forces of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities or may enter into co-production, joint venture, or production sharing agreements with Filipino citizens or corporations or associations, at least 60% of whose capital is owned by such citizens. Such agreements may be for a period not exceeding 25 years, renewable for not more than 25 years, and under such terms and conditions as may be provided by law. Retired senior Supreme Court Justice Antonio Carpio also gave his opinion recently on this matter in another forum, and I quote, telcos like PLDT or Globe utilize radio frequencies and must be 60% Filipino-owned since they utilize a natural resource. In addition, telcos are public utilities because they provide an essential service to the public for a fee, and therefore it must be 60% Filipino-owned. In short, a telco must be 60% Filipino-owned. End of quote. And now, going back to the deliberations of the Constitutional Commission, we refer once again to the chairwoman Munoz Palma stating that, and I quote, if the members will recall, the chair was called upon to rule actually first whether the subject of commercial telecommunications was included in the discussion of the section on public utilities in the article on national economy and patrimony. So I had to refer to the transcript of the proceedings on that particular day. It appears to be August 23rd. And I stated that the subject of commercial telecommunications was in fact included in the deliberations and in the decisions of the body with respect to the issue of ownership, which is the 60-40% equity ratio. And clearly, in the last sentence of Section 2, Article 12 of the Constitution, or the section on national economy and patrimony, the state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreements with Filipino citizens or corporations, associations, at least 60% of whose capital is owned by such citizens. And this can only refer to entities who need to be 60-40 in favor of Filipino, and such agreements are in the nature of Congress giving franchises to those who are duly qualified to use these frequencies. So I ask, so can Congress simply abrogate all these constitutional requirements, and will the Supreme Court allow an amendment to the Constitution by ordinary legislation without a constituent assembly or a constitutional convention and without a ratification by the people, or probably in simple terms, can a legislation with good intention justify an amendment to the Constitution? So let us proceed to number 3 to see what are the possible legal ramifications. Assuming an open access law that will adopt the House version, what will happen now move forward? No company now who would want to engage in the telecom business will see the need to apply for a franchise anymore. Or the corollary is that current telcos who have their franchises expiring will see no need to renew their franchises anymore. Considering that the basic telephone era is basically over and the only telecom business actually thriving now is the internet or the data business. The legacy business of companies using copper or local circuit switches have been relegated to the graveyard. Let us make no qualms about it. The data transmission industry is the only telecom business to speak of at present. Number 2, Congress will lose the oversight over telcos and the transfer of assets, usufruct or rights such as their frequency assignments. Number 3, broadcast companies will also now engage in the data transmission business, which will be contrary to Article 2, Section 5 of RA 7925, which states that no single franchise shall authorize an entity to engage in both telecommunications and broadcasting, either through the airwaves or by cable. And number 4, the public will be deprived of the opportunity to own such communication entities and shall deviate from the constitutional requirement that the state shall encourage equity participation in public utilities by the general public. This constitutional policy is implemented by incorporating in the franchises of public telecommunications the obligation to offer a portion of its outstanding capital shares to the public. And lastly, some recommendations to make the open access will genuinely address or bridge the digital divide gap. Taking off from the bill itself, and in order to guarantee the policy laid by the Open Access Bill, which is to narrow the digital divide in the country, encouraging the development of data transmission infrastructure. Number 1, maybe it would be better to put rollout commitments for data transmission participants to ensure connectivity, especially in unserved and underserved areas, if only in the interest of equality of treatment, the way RA 7925 set forth specific number of lines. As you may recall, IGF operators were made to roll out 300,000 lines and CMTS operators 400,000 lines way back in 1995. Or there should be a codification of existing telecommunication laws instead of amendments. And open access may form part and parcel of this codified set of laws. There's a need to codify the various telecommunication laws in order to avoid a situation where telecommunication laws are spread across several laws, such as the Public Service Act, Radio Control Law, and RA 7925. Actually, we in the PCTO, or the Philippine Chamber of Telecom Operators, pointed this out already 2 years ago when we submitted our position paper on this bill. A codified telecommunications law should expressly repeal outdated laws and consolidate all telecommunication laws under one law to avoid conflicting interpretations from piecemeal amendments, which only tends to promote litigation that will ultimately be detrimental to the public. Codification of telecommunication laws will once and for all clear up legislative ambivalence between tighter regulation and more extensive deregulation. That is all I can say for now. Thank you very much.
Thank you, Roy. Let's see. Our third speaker is Professor Oliver Reyes. He has actually I had a chat with him. He says he will not make his comments. He'll just jump in on the open forum. But I'll introduce him anyway. So Professor Oliver Reyes is the policy officer at the UP Law Center. He obtained his Juris Doctor degree at the UP College of Law and is a policy officer at the Digital Freedom Network. He worked before at the Supreme Court on the subcommittee on rules for special commercial courts, as well as he drafting the manual on judicial writing. He was for a time the senior program manager at the American Bar Association's Rule of Law Initiative project. He's a founder of democracy.net.ph and is a professorial lecturer at De La Salle, Far Eastern University, Lyceum of the Philippines College of Law, as well as the UP College of Law. Okay. I am. So we're at that part of the prior to going to the open forum. I just like to do a shout out to. I'm trying to see if I missed anyone here. I'm going to do a shout out for the people who are with us. Okay. Okay, I think I got it. Hindi na to ano, hindi na to north to south. So the people who ano, we've got people joining us from Bicol, from Subic, Makati, Cainta, Dasmariñas, Cavite, PUP Santa Mesa, Mandaluyong, Naga City, and did I say Digo City, Davao del Sur? So I'm trying to think whether we caught somebody in the Visayas, but it seems we have people from Mindanao and Luzon. So on that note, can I ask our panelists to turn on their cameras, and then we'll go to the Q&A. All right. Thank you. Siguro yun yung first for the discussion. I'm wondering, maybe Oli, you want to throw the first question if you have a question?
So maybe my first question would be, okay, so I think that a lot of the drive or the demand for the open access bill has also come about to the perceived uh, insufficiency of appropriate regulatory action from the National Telecommunications Commission that would ensure better internet speeds, better internet access for the general public. And I'm just wondering, even let's assume that even if while the bill is pending, and of course it's an uncertainty yet whether it would pass, I'm just curious, what do you think are interim measures that the NTC, which is the lead regulator for the telco industry, could adopt in order to at least initially address? I mean, there's obviously a strong demand for improved internet access. So I just like your thoughts about what do you think the NTC can do in the interim, which it can already do under its current mandate.
Ollie, maybe I can start.
Yeah.
Okay.
Okay. Of course, speaking on behalf of the consumers and the civil society, one of the major difficulties that we've had ever since about poor internet connectivity and regulation is that the NTC has always said that it is hands off when it comes to internet services. So if you are getting an answer like that, what regulatory action can we expect? And they would always, of course, cite the laws that we have. So I do not know how else to solve that if that is the position of the NTC. But of course, because we should not just stop there, policy reform advocates have also looked at regulatory reforms, one of which was the issuance of the memorandum circular in measuring and publishing broadband quality of service. However, unfortunately, that memorandum circular, according to the NTC, seems to be not enough because they're unable to measure broadband quality. The NTC, as far as I know, has adopted a methodology that would require NTC representatives to go to each and every premise, a house, an office, etc., and test the internet connectivity of subscribers from the premises. Of course, being one of the participants of the technical working group on that memorandum circular, we have always suggested that a more consumer-friendly and something that's more accessible should be used by the NTC. And there are a lot of examples already of these measurement applications and tools that are available out there, and we shouldn't reinvent the wheel. So I hope that there can be some improvements in terms of enforcing that memorandum circular for fixed broadband and mobile broadband. Um, but of course, that is only one aspect of it. I mean, that is for ensuring that the consumers get what they pay for. So I would really suggest that I hope that regulation should not only focus on um, obligating the service providers to expand their services in areas where there is still no connectivity, but also make sure that uh, people who already are subscribed to their service actually get what they pay for. So yeah.
Okay.
Yeah. Okay.
So I have my sorry, Roy, did you want
Yeah.
to
Yeah.
say something?
Just yeah.
Sure.
Well, first of all, no. Actually, the MTC and the DICT since the start of this pandemic have been very helpful to us telcos in terms of facilitating access to a lot of these sites that needed repair or installation and that were on lockdown. And for that, we were very thankful. No? But then again, currently, we're actually undergoing an exercise with the MTC to review a lot of the memorandum circulars related to spectrum. And among those that we wanted to address, in terms of the spectrum policy, is that we would like really to bring down the cost of spectrum because we all know that well, it's in economics. If your cost of production is high, then therefore everything will therefore be translated into high costs also, and the prices are going to be high. But if you cut your costs, then you can reallocate a lot of the savings to roll out more towers, to roll out more fiber, and all that. So, and that's what we're trying to work out with the NTC, if we can find an alternative method to compute for spectrum users fee. And I heard that the Singapore IDA recently adopted a very new novel approach to spectrum computation. They have drastically, I think, reduced the cost of SUF by computing it on a per 5 megahertz basis, and they assign something like cost only of 7,700 Singapore dollars per 5 megahertz. So if you convert that to pesos, if that will be the base figure, if the NTC will be open to adopt to that method of computing the SUF, that will reduce a lot of our cost, and that would translate to more savings. Yeah.
I'm wondering if so I'm not sure if I completely understand. No, I guess I'm coming from also from a standpoint of ignorance here. So maybe we can split the issue into two, because I'm thinking maybe we discuss fixed line independent of the spectrum issue, because which if you had sorry, maybe I'll step back. It seems to me that the current situation is governed, and I think both of you will agree, is governed by RA 7925. This is the 1995 or 97 Public Telecommunications Policy Act. And in that law, there is a provision for what's known as value-added service providers, who are not telcos, but they are, in fact, they're not required to get a franchise. They're only required to register. They're not required to get any license from the NTC. And back in the 90s, I remember back when it was dial-up, there were a lot of internet service providers under this law. And I'm wondering, right now, these service providers are no longer here. We're left with a handful. And I'm wondering, why can't we use that regulatory framework to move forward? And or is that also part of the problem? Maybe Grace?
Yeah, let me
Yeah, go ahead.
address JJ. Yeah, well, actually, when you say value-added service provider, the limitation for the vast players who register as an internet service provider under that provision is that they are not allowed to roll out their own network infrastructure. So they would have to contend with, or they have to lease the infrastructure from the PTE, or the
Yes.
telecom service provider.
Yeah, actually,
Yeah.
I was a bit. Yeah, go ahead. Go ahead.
Okay lang, yeah. Sige.
Yes.
Of course, among us, I'm not the lawyer,
Yes.
but I do consult with other legal experts. So as far as I understand it, RA 7925, when it was passed, the internet was relatively unknown in the Philippines, and it was non-existent in many places. In fact, I think it was only in the academic institutions where the internet was actually used. No, but the the way I understand it, when you define something in a law, um, you cannot really assume that you encompass um, everything that may not be existing at the time. Kasi insofar as RA 7925, I think four kinds of networks were defined: the international carrier, the inter-exchange carrier, the cellular mobile telephone system, and the local exchange carrier or your landline network.
Yes.
So I would say that the prohibition of vast providers in terms of owning a network would be only limited to owning those networks that were defined in RE 7925.
So
Um,
you're saying that on a retail level, they can build their network. So for example, they can build a network within, say, a subdivision, but they connect to a larger network. Is that what you're referring to?
but that is already what is happening now.
Mhm.
The contention of other legal experts is that since RA 7925 defined specific types of telecom networks, then essentially your vast providers are prohibited from building those networks that were defined in RA 7925. That is
Okay.
my layman's understanding, my laywoman's understanding of it. The second part is that if you are prohibiting vast providers from building their own network and requiring them to connect or use the facilities of a telecom service provider, a telco, but then the telco itself is not prohibited from competing with the vast providers who are their clients in the same retail market, then you have a lopsided situation where the wholesalers can compete with the retailers. So I don't, as you mentioned, JJ, you no longer see these bus providers simply because many of them have either closed down or were probably bought out, but because there are limitations for them to grow and thrive.
I think
Just to give you an, yeah.
yeah, go ahead. No, the restriction on putting up the network is in RA 7925. So it's very explicit they can't do that. I think the if I read the 7925, my read of it is uh, value-added service providers are supposed to buy services from the PTEs. These are the telcos, right? So GlobeSmart, PLDT, and then they offer their services. And then there's a provision here that so they can compete with the PTEs. The PTEs are supposed to have some control so that there's no cross subsidy within. In other words, if PLDT will set a price, they'll say, okay, VAS provider, here's the price I'm selling it to you. But you know what? This is the price I'm selling to myself as well. And so we're competing sort of on equal footing in the marketplace. But I'm wondering to whether or not this was enough of a protection, simply because there are no independent service providers operating under the VAS model. So maybe would it be safe to say? Would you agree with me that the VAS model is broken, or maybe it failed its objective?
Well, first of all, it's unclear what kind of network are we talking about. Network is not even defined in RA 7925. What is
Yes.
defined by enumeration is the type of telecom networks, which I already mentioned earlier.
Correct. I think
So
the understanding is that there's no physical layer These guys don't lay out which actually, here's my other thinking. I know Attorney Ibay mentioned earlier the Constitution, and I think you were referring to the provision on public utility, no? Is that right, Roy?
Yes, yes.
And the public utility is limited to 60/40. And I was thinking about this because it really didn't make sense to my mind. Maybe I'm not well versed on telecom law, but when it comes to public utility, my understanding is, or my interpretation is, that it refers to public service. In other words, your customer is the general public.
Yes.
But if I buy wholesale, say, internet from, say, and I don't retail it, right? And I just run a network where I sell to other wholesalers, then I don't have to be, I'm not a public utility. In much the same way, for example, that a power producer, if I run a power plant and I generate electricity, and because I don't sell to customers directly, instead I sell to power distributors, right? Ano ba tawag doon? The Maralco, for example, who deal with customers. The power producer does not have to get a franchise. I wonder if the definition of public utility in the Constitution can accommodate that, if only to open up to foreign ownership. What do you think?
Well, actually, I think it was also during that same forum where I listened to retired Justice Carpio. He was saying that the Constitution itself doesn't have a definition of terms. Yeah. So that's why
Correct.
you really have to revert back to the journals of the Constitutional Convention when all the different commissioners were discussing and defining, no, during the deliberations what the intention was in writing those provisions in our Constitution. So
And then they were mentioning telecom. I think that's your argument, no?
yes, so it's
No.
kind of difficult that if you will go into the habit of well, defining out of a general definition sub definitions, it's a bit dangerous because well, we can go on and target so many concepts or framework of the words in the Constitution and start redefining them or redefining them and come up with a legislation with a good intent, and before you know it, you already did a backdoor constitutional amendment, and you get to implement it.
So it's interesting you mentioned that, because I mean, my view there is that the Constitution is a living document. So there's this Supreme Court case called Laurel versus Abrogar, which I'm sure you're familiar with. In Laurel versus Abrogar, the issue was whether somebody could be convicted for stealing a telephone call. And the Supreme Court ruled eventually that a telephone call could not be stolen because at the time when the law was enacted, that type of telephone call back in the 30s, the revised penal code was in the 30s, he said that technology did not exist. And then, when we look back at the Constitutional Commission deliberations, which were in 1987, probably, 87, 86, the internet did not exist in the Philippines. So when they spoke of telecom, perhaps it should be understood in the context on the state of the telecommunication technology as of that time, in which case it would be limited to voice. I'm just suggesting that. And yeah, go ahead.
Actually, I agree with you. In fact, that was why I wrote or what I discussed earlier during my presentation, that assuming it's okay that you open up the 4 segments, diba? The international, the core, the middle mile, the last mile. But one thing is clear is the use of spectrum, because that I think is very explicit. So I limited my challenge to that, no? Being a scarce public resource and being mentioned explicitly that to utilize such public resource, you need a franchise, and at least you should be Filipino or a corporation that has to be 60/40. All others debatable because tama ka, di ba? Yeah, that's in fact the fixed, the use of cable, etc. Yeah.
Yes, because there's this other provision which is mass media. and the Constitution says mass media is 100% Filipino, which was an afterthought because it's in the transitory provision. And yet, I think if you want to make sense, because the interpretation of the SEC is that anybody who communicates in public is engaged in mass media. And therefore, you can slice and dice that in so many different ways. And you can even try to think, well, isn't PLDT providing the platform for others to communicate to the public, and isn't that what mass media does? And you could say PLDT is a mass media company, but then that does not help. And the way I like to think about mass media is that maybe one way out of it is to look at the state of the technology at the time when that constitutional provision was enacted, and then limit it to that. Diba kasi dati you have to have access to government resources, such as spectrum, in order to engage in mass media. So, Ollie, you wanted to say something?
Yeah, there are just 3 points I'd like to bring into the mix. So first, about constitutional interpretation, I think it's worth mentioning that while reliance on the so-called original intent of the framers, or what they thought at the time that they wrote the document or the Constitution, has long been maybe even the default choice of constitutional interpretation. It's not the only means by which, or the only method by which a constitution is interpreted. Second, and related to that, I think that at least in one instance, Divina Gracia versus CBS, the Supreme Court did apply a free speech analysis in construing essentially the regulatory framework, at least towards the end of, against the regulatory authority and allowing for the broadcaster to continue. So that sort of framework, and of course, it's a Bill of Rights. And I think the Supreme Court has recently come around to the view that the Bill of Rights is a preferred, occupies a position of primacy within the Constitution. So that interpretation, or rather that frame of analysis, could also come into play when it interprets provisions such as even the public utilities or mass media, or against interpreting the Constitution in such a way that might restrict or inhibit speech. So that's a possibility. And third, about spectrum, I think it's worth also, because again, as Attorney Roy said, the original reason why broadcast is more strictly regulated than, let's say, print media and other media, because of the perceived scarcity of resources. That the spectrum is a scarce resource, and therefore the state must come in and intervene. And because of the scarcity, the state can play this active role in determining
Licensing.
who can enter and who cannot. But even scarcity as a physical reality, that may have been more true back in the when the scarcity doctrine was first developed in the 20s to 60s. But it's not very much the case anymore. And in fact, I know that in the US, at least a district court, where it was actually just Judge Bork, concurred in by Judge Scalia, wherein they said that scarcity did not apply to cable. So therefore, the scarcity analysis and the state role in determining who can be allowed the right to operate the cable, there's no proper role of the state there, because the scarcity, which was the main justification for the state being the gatekeeper, did not exist, at least in cable. So that may be a analysis that may come to increasingly more use here.
Yeah, may I comment, JJ? So
Sure,
actually,
sure.
with regard to spectrum, well, I'm not saying that all spectrum should be used by the duly enfranchised. There are actually open and unlicensed spectrum that even non-enfranchised players can utilize. No, in fact, this is contained in the Senate version of the Faster Internet Bill as filed by Senator Recto, and we agree with that bill. No, we agree with that provision where explicitly he made mention that internet providers should not go into the business of the PTEs, but can utilize frequencies or spectrum that are open and unlicensed. And to that, we agree. Yeah.
Yeah. Actually, when I was listening to Ollie and he was saying that because I think spectrum was scarce before because of the fear of interference, and so they have to assign frequencies far from each other because there will be interference. But now with digital, you can be more efficient in dividing spectrum, useful spectrum, and I think that would play into the argument of Attorney Ibay earlier, where he says that the prices should go down because if it is less scarce, then arguably there's more of it to go around. And if there's more of it to go around, given the demand, relatively the price should go down. And I have a tendency to agree that the issue on spectrum perhaps is less on the constitutional issue, but perhaps as a pricing issue and a model. And of course, I think because we're both from Econ, our professors taught us that what you want is the most efficient. You want one who can use the resource with the most efficiency should have control over that resource. So I think what we want to do with spectrum is to prevent somebody who gets a right to a spectrum is not using it, but instead is squatting on it. So it's a bit like land ownership. So that's the problem with land ownership, where I buy the land, and even if I'm not using it for any useful purpose, and somebody else can do that, I can block that person out because of my rights. And there's actually a solution to that. But I don't know if we have time to discuss it. But I think that model will work insofar as insofar as spectrum is concerned. How about I'm concerned about
Sorry, can I just
go ahead.
Before we leave the spectrum issue, just to put some context. In the Philippines, we don't assign spectrum via auction. So that is one of the reasons I'm guessing why our spectrum user fees are the way they are. In other countries, actually in most countries, it is via auction that spectrum is assigned, and operators in those countries pay an enormous amount. That is not to say that I prescribe to that, because I believe that auction can only be effective if you have competition in the market and there's a level playing field and you don't have dominant market players. So I would suggest that we should review the SUF that we have now. It is very confusing actually how SUF is computed. There are so many memorandum circulars by the NTC, and it depends. It also is technology specific, which again I think is not the path that we want to take. But again, going back to the point of spectrum not being scarce anymore, from a consumer's perspective, I would really want to see how our policy and regulatory framework can allow a more democratized use of wireless technologies. And as we know, wireless technologies use spectrum, because we will never probably reach a point where we can achieve universal access if spectrum is concentrated in the hands of a few.
Okay. So I guess in my mind, I'm thinking the wireless spectrum issue is relevant for data on mobile networks. So maybe I'm wrong on that point, and I'm thinking all the other issues on access to internet or internet speed in the country can be solved by cable, right? A submarine cable connecting Luzon, Visayas, Mindanao. And then it's just a matter of who's going to lay those out and then whether there's competition at the local level in terms of rolling out those networks. Am I mistaken, or?
Well, actually, JJ, let me just make a case, no, also how important fiber is at this point, no. Before this pandemic, I guess it was true for the wireless carriers, no, like Globe and Smart, really to be fully just reliant on the wireless technologies. But because of this pandemic, we realized that the bandwidth that a wireless technology can offer is is so much limited. So,
Mm.
but good thing, no, being a fully integrated telco, PLDT Smart, PLDT, even before this pandemic, was already equipped, no, by expanding and also mobilizing their fiber in areas outside not only the business centers but also in the residential area. So when the pandemic happened and the traffic actually moved, no, from the business center to the residential areas, and a lot of the wireless the burden for the wireless traffic also suddenly surged. It was good that Smart had some of its connection fibered already, because we were, of course, partnered with PLDT, and that was they nasalo, no, it was able to carry a lot of this sudden surge or heavy traffic in a lot of residential areas. So I'm not saying that it 100% worked, no, but what we're saying is that, or we 100% addressed all these sudden demand, no? But
Okay.
I think majority we were able to carry and to address all the surge in traffic even when the pandemic happened.
Yeah. It is ideally we can fiberize the whole country. It is still the gold standard when it comes to high bandwidth capacity. However, we need to recognize the fact that there is also the affordability issue. Not everyone can afford to have wired broadband connectivity. We hope that with more competition in the fixed broadband segment, that there will be lower prices. But the the cost of really rolling out cable or wired network is really quite high as you go to areas with low population density. That's
Yes.
why I would like to emphasize
Wireless.
that wireless technology really has to have a place in how we intend to connect the country.
Okay.
As a researcher, as a policy researcher, I also do a lot of field work, and that's really where you find out what our kababayans are experiencing in the countryside. So while while um, while most of the cellular towers are, of course, in ideally in the provinces, you need to have fiber going there to
Mm.
ensure that they have bandwidth. Kaya lang hindi siya nangyayari. In many places, unfortunately, microwave na lang yung nagbabato ng
Okay.
bandwidth doon sa mga ano na yon, sa mga lugar na yun. Pero may iba kasing wireless technologies that you can use na may mas higher capacity and yung propagation ay mas malaki. And we need to ensure that those different technologies are being accommodated, especially for unserved and underserved areas.
But I guess in underserved areas, there would be that spectrum would probably be free because as it's underserved, there are not enough population, and therefore the spectrum would be free to be utilized by whoever wants to use it. Or is that a wrong
No,
assumption?
that's the
How
thing.
come? Who's running? Yeah, go ahead.
We do not have a framework other than our Act 3846 governing spectrum distribution. One example would be the study recently conducted by the UP College of Engineering, where they built a community network in Aurora, and they were
Mhm.
able to get access to 2G frequency so that they can provide 2G and so that people can at least make SMS and calls in certain villages in Aurora. Pero nakikiusap lang sila sa telco. Even if the telcos are not there, community networks are not allowed to use frequency. So
Okay.
we really need to address that gap in places where spectrum, as you mentioned, should logically be free, but there are no facilities. Kasi nationwide, usually yung assignment ng spectrum, what will happen to those people? So again, this is just part of the discussion that we're having, and I'm glad that Congress is now looking into spectrum management.
Great.
JJ, yeah, I'd
Go
like
ahead.
to add. Yeah, I agree with Grace. That's why I was suggesting, diba, how to tweak the open access to make it more responsive to bridging the digital divide. Maybe if you obligate all the so-called data transmission participants, similar to what RA 7925 did, to roll out fiber in those areas, especially the served, unserved, and those areas where internet is lacking. And I think the DICT has it right. They are actually really pushing for a bigger budget. They were only given, I think, 900 million by Congress, and they're asking Senate for a bigger budget so that they can be the ones who can provide the middle mile to those areas that are served and
Underserved.
unserved and underserved, no? So
Yeah.
that the any other free Wi-Fi participant can extend to the last mile whatever bandwidth that is needed for those areas. And I think that has also been pointed out by the NTC in many of their examples. A lot of governments really took, I don't know, took their own did their share, no, in terms of providing bandwidth, in terms of providing national backbone, and didn't just step aside and let the private sector, handle everything from ground up. And that's what happened, I think, with 7925. You had the 11 players. You cut up the country in 11 sectors where you have highly profitable and under profitable. And look what happened, no? 25, 30 years after the 7925, you still have a few players coming from those 11 players, because basically there were a lot of lines that were put up in
Under
areas there were really
Yes.
no takers, and they just overspent their capital just to comply
Correct.
with the requirements.
Yeah.
So
Sorry.
that's precisely my thinking also when you mentioned that earlier, Roy. No, I remember that's precisely what happened in 7925. What happened was, instead of more competition, the competition was saddled with this extra capital outlay, and therefore they became uncompetitive. And therefore, I'm wondering whether, I mean, these areas are underserved for the simple reason that there are not enough people. The market cannot sustain services to them. And if we would require new entrants to undertake that, then that it forms a sort of a barrier to entry, unless you're giving that the new entrant access to the already lucrative markets that are existing, say in the metropolitan areas, and you say, okay, let's carve up Metro Manila, diba? And then expose the current incumbents also to those.
No, but I'm
Yeah.
not saying that, I don't know. Maybe a correct number can be computed as to what lines can they
Yeah.
provision in the unserved and underserved, and with the afterthought that the DICT will support them at least on the core in the middle mile, no, for with all the national broadband projects that they're implementing right now. Unlike before, when the 11 players, they
Yeah.
really had to implement all these lines from the gateway all the way to the core, middle mile, and to the last mile. No? So
Okay.
the DICT will really have to play a big role, no, in terms of assisting a lot of not only the existing players right now, but also the new ones that intend to come in, no, in order to make it work, make it feasible.
Right.
Yeah.
Grace, you have
Yes.
to say something.
Right. Siguro let's learn from history, no? One of the reasons why we are, at least for the for the landline era, why things did not work out is precisely because the policy was technology specific. Why require deployment of landlines? Why require deployment of fiber? I would strongly suggest that we stay away from becoming, from being technology specific again. Because you would want to give the leeway naman to service providers as to what type of technology they deem fit for a particular area that needs to be served. um, Siguro let's not repeat the same mistakes that we experienced, no, when it was the landline technology that was the most dominant. And secondly, we should also be very careful in suggesting that it should be the government that should spend for deploying and operating infrastructure. Again, learning from experience and from history, we have the tell-off in the municipal telephone office as very grave reminders of how the government should not be given the lead role or at least no, not we should not depend on the government for things like infrastructure and operating as a telco. I would seriously want to rethink that suggestion. What the government is, its primary role should really be ensuring that the policy and regulation are going to are fit for the modern day communication and connectivity challenges and issues that we are experiencing, and create an environment where you don't have barriers to entry, where you are allowing innovation and business models to emerge and thrive. So that is my 2 cents into this discussion.
It's funny you mentioned Telof. Back in the day, when I after I took the bar, we went up to Sagada. Wala pang mobile phones noon. This was 1993. And I actually did have an opportunity to walk into a Telof office in order to make a phone call from Sagada to Metro Manila. So that, but I'm wondering whether Telof still exists.
It
Do
was
they, or
absorbed. Telof was
Yeah.
absorbed by the DICT. But
but
just to
absorbed in a nice way, or absorbed just carried over 100 million worth of salaries
I-
of telephone lines at
Mahabang
RTP.
kwentuhan yan, JJ.
Yeah.
Mahabang
Okay,
kwentuhan
okay.
yan.
Pero
But
ano
let's
lang,
go there.
sorry,
Yeah,
can I
go
just
ahead.
add, no? Can I just add? The DICT with the National Broadband Plan and Infrastructure, I think is targeting to connect areas where there might not be, market players who would be willing to go to these areas.
Yes.
I think
Yes.
that is a good starting point.
Yes.
But
Okay.
for areas, and also just to point out, the national integrated infrastructure that's being planned by the DICT is only enough to address the government's connectivity requirement. That's what the DICT made clear in all of its presentations. But the second point I'd like to make is that for areas where there are service providers, big ones or small ones, but I'm of course particularly interested in the small ones that can actually provide the connectivity not only in the last mile but even in the middle mile to connect to the nearest point of presence. Why shouldn't we allow them to do so? That to me, if you don't allow that to happen, then you are actually not only preventing those communities that are being served by those service providers from getting connectivity, which of course is against the state policy of achieving universal access, but you are also uh, not giving the opportunity for these private service providers to grow, which of course is in RA 7925 and even in the Constitution.
Actually, Grace, there are laws right now that allow that, no? You have the free public Wi-Fi, diba? The program is that the ICT you enter into partnership with the ICT, private providers, and if you're not enfranchised, can partner with VICT to provide bandwidth in all those unserved and underserved areas. And I think that's fully functioning right now. No, I'd just like to say that um, it's clearly in most countries really the role of the government can never be discounted. Although ideally we can say we should always say that we government should step back and let the private sector do everything. But clearly since 7925 up to now, it hasn't really happened because the economics of it all is that it's not there's really so much cost being an archipelago of laying out so much fiber, so much transmission, whether it's wired or wireless, in all the unserved and underserved areas, such that government really has to step in and do its share. And I think that has been also the analysis of the NTC and the DICT, and that is why they're really pushing for a bigger budget so that they can also help out the private sector and all new players, new entrants, so that they won't be burdened to do an end-to-end rollout of facilities and just limit themselves down to the last mile. No?
That is
Okay.
precisely what the Open Access Bill is suggesting. It's proposing to make sure that there
No,
is
but the
competition.
Congress version,
Yes.
you're getting into also the business of the PTE, meaning from the landing station to the core, to the middle mile, and well, of course, to the last mile. The sided version is better because it specifically reserves portions of those segments to duly enfranchised players.
Magkaiba kasi kami ng definition ni Attorney Roy. I'm talking about internet service, not telecom.
Mm-hmm.
Yeah, I think there's that. I got that. I think that this idea of whether it's telecom or not telecom is something that is one of the key points. And just to interject. One of our former professors at the School of Economics and became the dean of the School of Economics is Dr. Raul Fabella, who is, I believe, a national scientist. And he famously, I am paraphrasing here because it was really a good quote. He said that I don't understand Filipinos. They want the government to do everything. And yet, during elections, they don't trust the government to count their votes. So if you don't trust the government to count your votes, why trust them to do anything? And I'm going to do that as a starting point. And I think both of you are in agreement that while government has a role, government should, put itself in the right concept. Right perspective. And my question is, I've read a few years back, there was a contract signed by the DICT, by Acting Secretary Rio, of bandwidth that was going to be provided by Facebook. And supposedly the massive amount of bandwidth, it will double the amount of available bandwidth. And I don't know, rightly or wrongly, the bandwidth is going to go to the government because the government is the counterparty in that arrangement. I don't know if it's the BCDA because BCDA is the signatory because they're traversing Luzon ata to move from east to west Luzon. Now, so that bandwidth, can government use that bandwidth, say with the National Grid Corporation, run it through the national grid, and then be able, anywhere where there's electricity, there's now an opportunity to give high-speed internet. What do you think, Grace?
Yeah, first of all, what will be given is cable capacity. So the government still needs to buy the internet that will traverse or go through that pipe. So that's
okay.
That's the exchange deal. As far as I recall, in all of the presentations of the DICT up to now, the intention really there is for the government to use the cable capacity and buy cheaper bandwidth because, as the ICT said, it's very expensive to buy down from the telcos. I'm just quoting them, the 1.5 terabits per second of cable capacity will be enough lang for government use. That is what the ICT said. The National Grid Corporation's fiber optic network will also be used for free, but only to distribute up to the substations. And from the substations, you need to make sure that there is equipment that will essentially light up the dark fiber and then distribute it to the government offices. So I do not know whether there will be any changes in the arrangement with Facebook or with the NGCP that would allow selling the bandwidth or the internet that the government will buy to commercial ISPs or directly to the public. So that is as far as I know. So another issue there is whether or not there is a policy that can be used to enable access to that capacity. Meaning, can the government just freely, if it decides to do so, can it just freely sell the bandwidth to internet service providers for commercial purposes? And then, who can have access to that bandwidth and what are the terms? So, ang alam ko, wala pang ganong arrangement as of now.
I think JJ lost his audio. So, Attorney Oliver, ikaw daw mag-moderate.
JJ is asking you to moderate, Oli.
Yeah.
Yeah.
Nawala siya.
Yeah, I just saw. Excuse me. Yeah, I just saw. I think actually we're close to wrapping up. I think so. I think that this has been a very Um, yeah, but I think that this has been a very energetic discussion, which has covered a lot of ground. And I think that well, the bottom line is ultimately what there is a demand for improved wider service, and I think that much of the public would not be especially particular of as to how they would get improved service as long as they do so. But of course, the devil is in the details, and in order to provide the improved service, it's not just a matter of saying that the service that there be a demand that the service should be improved, but there must be not just a physical infrastructure but also a legal infrastructure that would make the best sense in order to essentially make it feasible for the market to naturally take up the cudgels and provide these services. So maybe with that, and I don't. Maybe if you have, maybe we can have some final words from our participants, or unless JJ has any other
No,
questions.
no, I'm good. I'm good.
Maybe you can have a start with Grace and Roy.
Sige. So again, thank you to the Sini Law for inviting me. This is a very timely and relevant topic, and I do hope that there will be some movement in Congress when it comes to open access. I have been enlightened by our fellow panelists, and I look forward to more discussion on this. Hopefully sa Congress na para alam nating gumagalaw yung bill. Thank you.
Thank you, Roy.
So again, thank you to my co-panelists, Attorney Oliver, Miss Grace, for taking part in this forum, and of course to Attorney JJ and the Sinilo. Sana makapag-jamming tayo ulit, Attorney JJ, like before. Oh.
Right.
So maraming salamat, and sana maulit.
Okay, thank you, Ollie. You have any parting words?
I think not much apart from what I earlier said, but I do hope that this unfortunate pandemic is one of the byproducts of the pandemic has been for our policymakers to start thinking more seriously about not just the prior to the pandemic, all things digital may have been perceived as an advantage, but now with the pandemic and all of the um, emergencies that it has led to, I think the policymakers are now realizing that it is not just an advantage but a need, and I hope that as that continued philosophy would would uh, would bear impact on our policymakers and our legislators. It's somewhat unfortunate that a lot of the needs or the gaps have to be addressed by legislation, and we know how long legislation would take. But I do hope that the resulting legislation would empower our policymakers with sufficient flexibility as to be able to address the evolving technologies as they come along. Thank you.
All right. So thank you. That's our episode this week. Our second episode this week. Na-delay lang po ng konti. Thank you to our guests, Grace, Attorney Roy, and Professor Ollie, for being here today. We'd like to invite everyone to the session next week on court resilience, where we will be talking about building a framework for effective digital and electronic proceedings in court. And we're hoping to present a solution where a provider can provide services to allow online hearings to be done. Again, to close, to remind everyone, if you want to get a certificate, please feel free to sign up, and then you will receive a unique link for that purpose. Thank you, and good afternoon.